Yeah, that one. Something.
Good afternoon, participants. Welcome to the second session of our IP Masterclass that commenced this morning at 7 o'clock. In the morning, we were able to go through the introduction with Elvine, and now we will be going into the second session where we'll be able to look at some of the disputes and the case studies. We will begin with the national anthem, and then we will be able to step right away with the presentation. We will recite the anthem in English. O God of all creation, bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace, and liberty. Plenty be found within our borders. Like I said, this is the second session, and Elvine will be taking us through this particular session. Good afternoon, Elvine.
Good afternoon, Sarah. How are you?
Okay, I pray that you had a good morning, and we are happy to have you with us again to be able to take us through this particular part. So you're welcome, and please get on with it. Thank you.
Thank you. I shall share my screen again. Give me a minute.
As Elvine is finding her screen, just let me just say that this is the 16th day of July, and we have been having a masterclass in IP that began in the morning at 7 o'clock and will be ending later today at 5 o'clock.
Sorry. Okay, well, I hope that we have the same people in the morning, just because we did the introductory part in the morning. So I changed the topic quite just a bit, called it dispute resolution rather than dispute management and case studies. So this is just a continuation of what we did in the morning based on what we spoke about, now looking at industrial property and how disputes arise from what we spoke about. I have up to we have up to 3:30. I'm hoping to have this as an interactive session so that each of you can also be able to see how you come in terms of mediation. So then, as earlier I had spoken about the rationale of granting these rights, exclusive rights, is basically for enforcement. And once there's enforcement, we believe that the backdrop to that is that there would be disputes. So I'd already talked about this in the morning. Most of us who are here would remember this, but I just thought this would be a nice place to begin. So as we said, that it is an act of compelling observance or compliance with the law. So basically, that's what we are looking at in terms of dispute resolution in industrial property from various angles. So I said that earlier in the morning that the Constitution, our laws are anchored on the Constitution, which is Article 45. The administrative part is that there is opposition. So what we do is opposition and expungement proceedings in KIPI. That I will get to specifically when we get there. So it's administrative, meaning it's part of our procedure. When you looked at the application procedure in the morning, you saw there was a part I said that we advertise and we allow people to object within 60 days. So this is what we call opposition proceedings that come before the registrar and the assistant registrars, and expungement proceedings these are removal proceedings as well. So civil procedure, normally, as we spoke in the morning, these are, when we talk about industrial property, these are marks, or rather if it's a trademark, if it's a patent, they are used in commerce. So they go to the commercial division of the High Court and the Industrial Property Tribunal. That is where once we have granted a patent or an industrial design, when someone seeks revocation, you go in at that point. Then there's criminal, which is, I'll show you that there are certain offenses under the Industrial Property Act and under the Trademarks Act that can land you in prison or in jail. That's what the implication is. So then there are border measures we spoke about in the morning. Customs and enforcement officers will look at the trademarks, or if I said that these are exclusive rights, so then they're territorial. So some of them move from one country to another into our jurisdiction. And so if these things are coming in with the wrong marks or forged marks, then you also can face actions that are punishable by law. So the proceedings, we'll begin with proceedings under the Industrial Property Act. I have seen some people who are also knowledgeable in the area. Forgive me, today I've been very simple because I want everyone to be on the same page, but I would want us to also have an interactive session. So I'll try to be very fast this afternoon so that we can be able to interact. So patents and utility models, that, as I explained in the morning, they do not have a dispute resolution mechanism before grant of a patent, just because of the confidentiality that is there as and just when you look at a patent application per se, when it's published, you wouldn't know exactly what it entails until grant. And so that's why the rationale was that you would ask for revocation upon grant. So there's no dispute resolution in between, that would be administrative. So what happens is that once the MD, the managing director under the Industrial Property Act, grants a patent, then revocation proceedings will begin at the Industrial Property Tribunal. Then if you are not satisfied, then you can go to the High Court, and then you go as per the hierarchy of the courts like that. Section 103(2) of the Act, sorry, here we'll have to deal with the law a bit, so I'll have to refer to the law, which I do not like because I don't want to complicate matters, but where I have to, I will mention the sections. Do not worry about the sections, just what it talks about. So this is revocation. So patents is that it's called revocation or invalidation, meaning something that has already been granted, you're seeking for the remedy that it be revoked from the register or invalidated. So this applies to the industrial properties that are under the Industrial Property Act, which is the industrial patents, utility models, and industrial designs. But for industrial designs, we have opposition proceedings. So this would be the exception. here we will talk about opposition proceedings under trademarks, and it also applies to industrial designs. A design you're able to see and know whether it is similar to yours or identical to yours. So it's a bit easier. It's not necessarily that you'd want to go and revoke it. That doesn't stop you from going to the tribunal, but we also have an administrative process in the office. So now we go to elements that sustain. I'll give a synopsis. It's so wide. I'll try and make it so simple so that we can ask more questions and that people can be able to understand. So what I will begin with is revocation, meaning we talked about the patentability criteria in the morning. I talked about a patent being new, involving an inventive step, and industrially applicable. So in the first instance, this would be the things that would take you to the tribunal or would render or would warrant an invalidation. So then it means when you're coming before the courts, you're trying to say that we granted a patent that is not new, meaning the onus of proof is on you, just meaning that you have the burden to prove that this thing is not new. It does not involve an inventive step, meaning it is obvious for people skilled in that area or that it is industrially. It is not applicable or useful for use. So then when you look at infringement, that's a big area, meaning we had said that we give exclusive rights to a party who comes before us seeking this protection. So once we have given you, it means the patent holder has a right to exclude others from exploiting their trademark. It's very important, meaning that before my permission, you're not allowed to exploit the invention in any manner. So if you exploit that invention, meaning selling, meaning distributing, meaning manufacturing, anything, importing, exporting without the permission of the patent right holder, it means then you're infringing on the patent. So it means the patent holder can bring proceedings against you, which can be done in the Industrial Property Tribunal or in the High Court. A High Court has original civil jurisdiction, so anyone can approach the High Court for an infringement case. Then we have, so the defendant, as I earlier said, you can claim that a patent is invalid, you file for invalidation based on revocation based on the 3 criteria or any other thing that you have seen is not proper in the grant, and you must prove the grounds as to why it should not have been granted. So as I earlier said, some of the sections, forget about the sections, but section 103 is that one for revocation or invalidation at the tribunal. So you will say it is not new. I've already said that. And we want to look at one case. So this is it's a Sanitam case. I didn't want to give the full. I think I have given it somewhere. So in this case, sorry, it was a regional granted patent. As if you remember from my presentation in the morning, I had stated earlier that we grant national patents, then we have an agreement that we have signed, the Harare Protocol, that is administered by the African Regional Intellectual Property Organization in Zimbabwe, Harare. So then an applicant can apply through a WIPO and have the application brought to KIPI, and then we grant the patent. So it's a filing system. It's not a granting system, it's a filing system. It makes it easier for people who want, as I said, they're territorial. So people who want their protection to be extended to different territories can use the regional option or come directly to the office or use the international phase, which is the Patent Corporation under the Patent Corporation Treaty. So this case, the Sanitam case, is about these beans that for people who, the ladies would know it well, the sanitary beans, the pedal that is used at the foot of the bean. The applicant was claiming that he's the one who has the right to that, the pedal mechanism in terms of the invention. So he was granted a patent through a WIPO, meaning it is applied through a WIPO, then it comes into the national phase. We are supposed to do examination and accept it or reject it. So at that point, I think there was a confusion, and the patent, when you do not respond within a certain time limit, so then it usually has a time limit, a year, 6 months, for the officers to respond and say whether you approve it or not. So then it will be deemed approved indefinitely without you saying otherwise. So it was approved. So the person came and was threatening everyone who is using the bins to stop. As I said, once you have been granted a patent, anyone who exploits the invention without your permission is infringing. So several people went into the tribunal to seek for revocation, and later he appealed to the High Court and lost. The details will come in later. So then there are certain exclusions in terms of when we give you a right. There are certain exclusions that certain patents that are not patentable. I'm talking about patents first because it's a bit complicated, then we'll go into trademarks. So I looked for a case that would give us a scenario where we exclude certain patents from inventions from being patentable, or rather are not patentable. So there's John Kamonjo Mwaura. I will not give the full citation. You'll get it in the presentation. This was an appeal, just a brief synopsis of what happened. At the tribunal, it was challenging a refusal by the managing director. As I said, under the Industrial Property Act, any action that is done in the name of the managing director. So this person went to court, the plaintiff, and we said that KIPI is a corporate body as well. We can be sued. So we were sued versus the managing director. This is a managing director of KIPI, this is a bank and Safaricom. Someone was coming up with a patent for a system and a computer implemented method for just giving loans. These are big words for a system an operating system for granting loans or financing. So the issues was that the examiner refused to grant this patent because it lacked inventive step. You remember the patentability criteria we talked about. So when we look into disputes, we are looking into the tenets, the basics, what is required for a patent. So when people are going to court, these are the things that will arise. And even as an independent, because alternative dispute resolution is consensual and people can get into it. These are the issues that would arise, that you'd know that these are part of the patentability criteria that we look at. So when we refuse, we have to give you reasons. So one of the reasons was that it lacks inventive step, meaning there was nothing that was non-obvious. That was the non-obvious rule, meaning it was obvious for people skilled in the art to come up with this system of advancing loans, or rather, as he called it, credit financing. So then they said it was described that the automation was a well-known conventional procedure. Then the examiner gave 2 US patent documents citing similar systems. So that means, you remember we had said that it has to be new all over the world. So we go through the database and we'll check whether there's novelty in what you're saying. Has it been, if you remember, I said that we have to check whether it has been disclosed anywhere before your application. So these patent documents are given to justify why we are not granting. So then again, it is an excluded protection. We do not give protection for methods. This was a method for doing business. If you remember, when we were giving the definition of a patent, we said that it can be a product, a process, or a method. So this person is claiming that he has come up with a method or a system. If you read the title of the invention, is a patent for a system and computer implemented method, meaning he was saying he has come up with a method, or to underwrite loans. And so what we were saying is that it is under Section 21(3)(b) of the Industrial Property Act. We do not protect methods of doing business. If you have a business plan, you know, it's important when you're doing a startup, but it will not be protectable under patent law. This is an exclusion. So this is what I also wanted to bring out so that you see the areas of dispute. So when someone comes and says, when you're coming into, when the managing director has refused to grant you a patent, when you bring out the grounds, some of this will arise in terms of dispute. So the managing director's decision was upheld and the appeal was dismissed in this matter. So when we look at section 21 now, because we've gone through our case, we can look at, we have said that we do not patent discoveries, scientific theories, because then it will not reach the threshold of it being new and involving an inventive step. Mathematical methods or formulas, those are things that are already in the public domain, so no one can claim exclusivity over such formulas or methods or theories. So we have said rules and methods of doing business, purely mental acts or playing games. There are people who come up with games, you know, different kinds of games that could be innovative in the field, but those ones are not patentable in terms of novelty, inventive step, and whether they are useful or not. So then and then there are methods of treatment of the human or animal body. They are also excluded under this section. Surgery or therapy, anything that, you know, things that are taught in school, methods or treatments, methods of treatment, they are not, as well as diagnostic methods practiced. That doesn't mean that if you come up with medication product, that would be allowable under patents. So except products for use in any such methods. So in relation to mere presentation of information, so you just brought for us information, we cannot be able to divulge and see the usefulness of it in relation to technology, then that also will not be patentable. So public health related methods of use or any other substances whatsoever used for the prevention or treatment of any disease, which the CES for health may designate as serious health hazard or as a life-threatening disease, may not be patentable. So this one we'll talk about when we, like now what is happening in terms of COVID, and we can see how it can be, we can go about it in terms of if someone came up with an invention and would want to withhold it, and it's something that is useful and may be beneficial to everyone, then we have certain sections that would force you to grant such inventions, force you in a legal way. So patents, when you talk about infringement as well, I say that it is within 20 years. So then it means that after the 20 years, there's no infringement. So that's very important. So we look at the filing date and when the acts of infringement arose. So that's also a very key aspect, especially when people are negotiating or when you look at alternative dispute resolution, we need to see whether these acts were done within the time frame that is given or out of the time frame. Then the issues of renewal or annuity, when they arise, when someone has not paid for annuity, what happens during times when there's alleged infringement. Then section 54 of the Industrial Property Act, it bars the making. I have talked about it. It means we cannot make, we cannot import, we cannot offer for sale, you cannot sell, you cannot stock for sale or use. You know, all these processes are barred for purposes of that exclusivity. It means that everything that you would see on that list needs permission if you are to exploit. And that's what we mean when we say that you're exploiting the invention. So any person exercising the rights without the authorization of the patent holder is committing an infringement. So the claims, I talked about them in the morning, are very key when we are determining infringement. It means that it's not the holistic, not necessarily the holistic thing. When we look at a patent, we look at it from the fence. Like when I talked about these are the beacons, The claim is the beacon. It would be the fence that now gives us and defines the rights of the patent holder. So we are coming from a place that is known. We have said, for instance, if I came up with a reclining chair, I will not claim rights over the chair itself. I'm claiming over the reclining mechanism in the chair. So that would be my claim. Another person, and sometimes there's interdependence between patents. Maybe the other person would have the right to the chair itself, and the next person would have the right to the reclining mechanism. So then this is where the claims become very key in determining the scope when we are determining disputes. So improvements, as we talked about, developments of earlier, here we have to determine whether you will obtain licenses, especially even when you're using someone else's patent to develop your own. You must ask for permission from the patent holder for you to be able to use and exploit it as you come up with your own. So then Section 106 also of the Patent of the Industrial Property Act gives interlocutory relief, meaning this is temporary for a simple term. These are injunctions. You know, when you want to stop the continuation of something, it's damaging. So you go to court. So this goes directly to the Industrial Property Tribunal or to the High Court. KIPI does not have jurisdiction to give these reliefs. So when the patent holder sees maybe someone importing, exporting, and it's causing him damage, so he can come and ask for an interlocutory relief to stop that or to stop the furtherance of the infringement. So then it's granted upon the request of the patent holder. This is before the tribunal I have talked about, so they are able to be given damages or any other remedy available in law, accounts of profits, special damages, whatever the circumstances as the case may be. Then Section 109 talks about intentional infringement. It is an offense, therefore it is criminal. There are people who do it intentionally, knowing. That means probably you have been served by a cease and desist letter and you have ignored, and then you continue, so then the amounts are there and the prison term. Also, I had talked about this case for Sanitam. It was Sanitam versus Rentokil, and the plaintiff succeeded in having it revoked by virtue of another patent that was discovered or disclosed by the parent company in UK and Malaysia. You remember we said that one of the grounds, so when you're revoking, in this case, you say that there's no novelty because there's already another pedal mechanism for that, the foot pedal mechanism on the bin, on the sanitary bin that had already been disclosed in the UK and Malaysia prior to the patent being granted in Kenya. And that now becomes a ground for revocation. So the defenses are that when acts are done by third parties necessary to obtain approval in terms of commercialization of a product after expiry. So the 20 years is very important as well. Some people would want to threaten people after that expiry of the patent. It is free for all. So then their prior use are using in good faith before the filing date. So this is also an exception in law when someone can be able to prove that they had no intention of infringing and they were using it prior to the filing date or the priority date. The priority date, as you remember when we were talking in the morning, I said that if I was to come up with a COVID drug in Kenya today, 16th of July 2020, and that's the beauty of that Paris Convention that we signed, and I go to the US 1 year after this, that or 12 months, just before the end of the 12 months, that would be 16th July 2021, maybe just on that day or a day before, I will still get the same date that I got in Kenya. That's what we call a priority date. So then my invention will still be 16th of July 2020, even in the US, meaning I have gotten a priority date because I had already, because of that convention and the fact that I had already applied or registered in Kenya. So that's what a priority date means. So acts done, so that means that if it was prior to that, or I had a priority date and I was using in good faith is very important, meaning that it's not in bad faith. Acts done for scientific research, when people are using the patent to advance technology, we do not want to stifle technology. That is an exception because it's not being used commercially. Parallel importation, that means that when there's always exhaustion of rights, that when I have already sold, and this is mostly used, I like using the example of the iPhone. They lock certain markets, they sell it in the US first, they sell it in Europe after they have gotten their markups and their sales, then they open it up for other markets. Now people are able to import it from China, from different countries at a cheaper price. The patent holder cannot come and claim rights again. There has to be an end to that right. So then that is also an exception for the patent holder to claim that people are infringing. Then there's use of articles on aircrafts. When aircraft vessels are moving from one territory to another, they are excluded or accidentally enter the space or airspace of Kenya, meaning that it was not intentional. So the patent holder cannot come and claim rights over it. And as I said, the 20-year period is very important in determining whether infringement has been done or not. Other limitations as to those rights are compulsory licenses. This is all disputes. When this is a non-voluntary license. We've talked about permission, meaning when you're given exclusive rights, you're able to give a person either a license or you sell it off completely. You can transfer the technology or whatever it is that you came up with in the invention and give it and get a one-off sale. Others would give it for specific areas, for specific claims that we talked about, and give certain conditions according to whatever agreements are entered into. So this is also very important, but the law recognizes, as I said, for instance, someone comes up with COVID-19 medication and now wants to hold it, and people are suffering and dying from it. The government can take up under this section a compulsory license, can grant you a compulsory license, so you'll be forced to negotiate a reasonable cost. Then you imagine we give monopoly over this. These are monopolistic rights, meaning I can dictate, like now I know people are in dire need of this medication or vaccine. So I come up with, I don't know, it's called remdesivir or whatever now that they're doing the runs. And then I realize that it's working. So I can say now it will be $1 million or 1 billion because I have monopoly in the market. So the government will be able to intervene because it's a pandemic, and they can take a compulsory license, just the way we would do it for land, the way you're chased out of your land by force. So this is the way we do it as well. So then we give you a license, but you will be compensated. And these are negotiable terms that are given by the government. So then when there's abuse of a patent as well, which could also be the same related, if you're abusing, you're not working a patent. For instance, I again would like to use I don't know if it's a bad or good example, or a good example if we are able to get a vaccine and then we are not working it. It is needed, it can be taken by force, and so it can be revoked on the basis that you are not working the patent, yet it is needed. For public interest, including health, as I've talked about it, even for COVID, we can decide to take it up, we'll pay you later because it's a pandemic and people need it for defense and development of an economy. For government use, there are also dependent patents. Example, I need your patent for me to advance another patent. For instance, again, for lack of a better example, for COVID, which is now with us, if I would want a solution so that, and I would want these rights, so that I can advance my other composition to come up with the vaccine, and someone is just being unreasonable, does not want to give me a license, we can come in under that section 80 for government use and use it to continue the process so that we can be able to come up with medication. I earlier talked about, so that's patents, basically, you know, in a nutshell. So it means that in all these processes, there are agreements, there's technology transfer, and there's it's prone to disputes between parties. So when I give you a license and you've overstepped your boundary, then there's a dispute. We can either look for alternatives in terms of alternative dispute resolution or go through the mainstream courts, which would take longer. Sometimes the technical expertise is lacking. So then it opens up an avenue for ADR to come in, especially on the issue of the expertise that is needed. This was there early in the morning, and for now, I just want to bring in the issue of dispute. When we get an application for a trademark, as I earlier said, we begin with a search. At the point of search, we can tell you that there is another mark on the register. So once we say the examiner tells you there's another mark owned by this person, we give you details of who the other owner is and why we feel the marks are similar. So then one of the options an applicant would have sometimes, and I'll talk about it when we talk about the positioning of mediators, one of the things we sometimes tell clients to do is to go and get a no objection letter. Meaning if you feel, for instance, there's an identical mark for a certain product and you feel that these products are different in the market, the channels of distribution are different, though they may look similar or identical, they may, consumers are able to distinguish them. If the other competitor has no issue and they write to us, we will grant that trademark. So then this can also be an issue of negotiation and allowing the other party to understand the intricacies of trademark law and the implications, or whether you will pay off and all these other things that could arise in terms of the limitations that they'll allow you to use both marks concurrently. Then, so when we talk about the written on our extreme, I don't know if it's your left or your right, where there's the trademark search and there's the written submissions or ex parte hearings on your screen. This ex parte hearing is between the applicant and the registrar. So it means advocates can come in, and when in that scenario where I'm talking about a cited mark, someone else has come into the picture, you can approach them and try and negotiate and see whether both marks can coexist in the register. Another way, another part that brings a dispute and conflict is publication. Once we publish a mark, we as the registrar, the registrar cannot be able to know how the marks are used in the market. So once we've checked our database and we are certain that, or rather by what we see, that both marks, or rather this mark can proceed to registration, we will allow the public also to check. That means competitors can also be able to look into the journal. Our journal is online and it's published monthly after every end of the month on our website. So then you look at the publications and you're able to check every mark and in what class they are proposed to be registered. And at this point, we give 60 days from the date of publication so that people can be able to object. So once they object, and a letter comes to, rather a notice of opposition, which is right, that it's my next slide. So then the proceedings begin. So these are also legal proceedings, but they're administrative. So we have a quasi-judicial role. We are able to go through the process until we come up with a ruling and a decision whether your mark should proceed or not. Expungement proceedings, as I earlier said, these are removal proceedings. It's just a fancy word for removal. So it means we expunge it from them. if you remember the election petition, some of you would remember something that needed to be expunged. So it's the same thing. So it's something that is on record and needs to be expunged. So it's expungement proceeding. So what happens is that maybe during the 60-day period, someone was not able to see the publication or the journal, and they have come to realize that this has been registered and it wrongly remains on the register. So there are proceedings, and so we go through the whole proceeding, and our ultimate decision will be made as to whether we will remove the mark from the register, and after removal, we publish it for the public to know that it no longer is registered with us, and if it is not removed, then it remains in the register as was. So then the opposition and expungement proceedings, these are dispute resolution proceedings. So we start with the notice of opposition. And ideally, the law says that you have to give a cease and desist letter before you bring someone to court. You must give them notice. So it's important that you write a letter so that if someone is able to withdraw at that point, they can be able to withdraw. So there's a notice of opposition that is filed with us at a fee, and then the counter statement also at a fee. So the notice of opposition now for people who are able to know what happens in mainstream litigation, that would be the plaint, and then the counter statement would be like a defense. So it means the notice of opposition begins the matter with us. So the matter is brought to the legal division where I work. And so I sit now as an assistant registrar. And now we start, we are a conduit. We send the documents to the applicant who was applying to say that someone has opposed your mark, and so they're supposed to defend themselves. If they do not defend themselves within a specified period, which is usually 42 days, or we allow for extensions of time. And now this is also another opportunity, and I'll also talk about it in the next session. So this is an opportunity where people can be able to now gauge and see whether they want to go through this whole process. It's a long process, it's a tedious process. We have companies that are registered abroad. That's why we grant 90 days lumps of extensions of time. It can take a long time. So at this point, someone can be able to decide whether he will just withdraw and leave the legal procedure, or negotiate on the side and see what they can do to amend, and in the interim continue to ask for extensions of time to hold the matter in abeyance. If they do not agree, then it will come back to us for determination. So then there's a counter statement. So I said it's like a defense. So someone says why the mark should be registered. Then there's something we call a statutory declaration, which is an affidavit that is sworn. So we take evidence, we take sworn evidence in terms of a declaration, but the registrar still has the honors to call witnesses, which we say is viva voce evidence. So you can come and in either in lieu or together. Let me not use too much legal language. So it means that you can come either in person together with the statutory declaration and bring witnesses, or we can say that you forgo that and just come, or whichever would be applicable. Then the opponent begins, because they're the ones who have brought the matter. We call them the opponent, the person who wants to object. Then the applicant will respond and swear, and this will be commissioned by a commissioner for oaths, and if it's coming from abroad, by a notary public. Then we will hear the matter, and it will be subject to appeal within 60 days. So in between here, as we go along, there could be certain things that would be taken into consideration as we look into whether the mark should be registered or not. I'll be speaking about it in a short while. So the same procedure applies. I talked about international marks. So the only difference is that for an international mark, the time frame would be longer. Under the agreement, which I told you is now obsolete, all the parties who had signed the agreement have now signed the protocol. So it means that we have 18 months for every contracting party, and Kenya is also a contracting party, why the World Intellectual Property Organization, we called it the International Bureau. It acts as a secretariat, as the center where we send, where countries can send the applications for international applications, and then they are transmitted to the various designated countries for us to consider the application in accordance to our laws. So it doesn't mean that when you go through the international phase, you have a different law that you're using. It's the same, it's just a simpler filing system that is used. So then again, trademarks, when you use a trademark, I said all these rights are exclusive rights, then you infringe. Section 7 states that you are infringing on a trademark if you do any acts without the authorization of the owner. So it's the same thing as it would happen to a patent that we have talked about. So then there's the law of tort. Tort is an act done against a person. These are individual rights. Section 5 also protects unregistered marks. If you remember, earlier I said that for patents is first to file. The person who comes to us first is the one who will be deemed the inventor. But now for trademarks, anyone who used the mark earlier, if you're able to show us that you have used the mark prior to you coming, then you get the prior, and even so, a trademark is still protected even if it is unregistered, which is under Section 5 of the Trademarks Act. The benefit of registration is that the law says that the certificate of registration is prima facie proof, meaning you do not need any other proof. Once you have the certificate, then you are ascertained that you are the owner. So opposition proceedings we do it for identical, so we look into whether the marks are identical, so it's whether confusingly similar. I'll give an example shortly. And for expungement, it's the same thing, but you're coming in a bit late. So it means the repercussion or the end result would be that we remove it from the register or expunge it. So there are exceptions as well. As we talked about exceptions in patents and defenses that you can use or a party can use or can be available when you're advising a party when they are negotiating. So the use of a person's name in good faith is one of those exceptions. And in this case, I've brought before you this Mabati rolling mills. I thought it was also important because there was a question on the company's registry and the synergy that should be there between the company registry and the trademark registry. This is one classical case. I will not go into the details because this matter is still going on. This one that I have highlighted was when they were asking for an injunction. Most of us would know MRM, Mabati Rolling Mills. They have been there for some time. Then versus Maisha Mabati. Maisha Mabati used to be Athi River Steel Rolling Mills. They changed their name with the company registrar. It's an interesting case to read for those who are looking, and I think it's important for the people who are asking in the morning about the connection and how we can work together. Once the person changed their name to Mabati Maisha, they changed their name to Maisha Mabati Mills. And so then Mabati Rolling Mills brought a trademark application for Maisha Mabati. And you can see it's confusingly similar. So this is the matter that is still even before the courts. It's still proceeding. So what happens, like now I would also want to talk about, I like talking about this one is that if you remember, we say that we look at different elements in the trademark registry that would not be looked at in the company's registry. Mabati means corrugated sheet. When you come under that class for corrugated sheets, which is where these trademarks are registered, when we look at Mabati itself, it's a descriptive mark, meaning it cannot belong to one person. The name Mabati can be used by anyone because it's the Kiswahili equivalent of corrugated sheets, which means the same, the it. It's like just me saying T, Mabati. So then this also becomes an area where when we advise clients and you're advising in terms of whether a dispute should come before the courts or not, as an alternative, sometimes it doesn't make sense to go through the whole litigation process because they do not understand that this is descriptive and it cannot pass as a trademark, and you cannot use it as a defense that it has become, unless you raise the issue of well-knownness, And the well-knownness that you have to raise, especially like for Mabati rolling, for them to say that the word Mabati now has been associated with them, that now when we think about Mabati, we do not think about corrugated sheet, we think about them. So these are some of the issues that would arise when we are handling the dispute. So when someone uses their name, because this was, I talked about the legal name, it could be a company name or an individual name. I used my name, Elvine, or some of you would know Coco Chanel, that's a name. So Mabati, this Athi River Steel Rolling Mills changed their name to Maisha Mabati Mills. So then everyone has a right to use their name if it's bona fide use. So these are the things that the courts are still grappling with in terms of whether both marks can be in the market. Then Matthew Asher Ochieng versus Kenya Oil Company. Sorry, this one, someone wanted to use a descriptive slogan saying proudly Kenyan. As I earlier said, there are certain common terms that we do not give a certain person. So whether you scream from here to Timbuktu, we cannot give you the word Kenya, nor every Kenyan would want to be, or rather, there are many people who are proud to be Kenyans, and they would want to also use the slogan. So slogans are ideally never registered as exclusive rights because they are very descriptive of the goods. So this is where, again, we look at now the synergy that could be there. There is a danger when the company registry grants, changes a name, which is their mandate. But now when the name coincides with a name that's already on the register, like what I'm talking about, Maisha Mabati and Mabati Maisha, then it becomes confusing in the market. When it comes under the Trademarks Act, we may use different rules than what the company registrar would use. Then there's something we call honest concurrent use, which is an exception. If both of us have been in the market almost at the same time, even if we are to use an identical mark, I don't know if most of us would remember those G4S, Securico, and there was the security firm. The one was so they had exactly the same features, the same, and they were in court at some point. Honest concurrent use, meaning the consumers are able to distinguish the goods and the services, even if the marks are identical. And the law allows the registrar to put certain conditions and restrictions so that people can be able to, I can tell one to use the color red, or you change your mark in such a form that you will only restrict it in these colors so that people can be able to distinguish and the consumers would never be confused. So I've talked about use of a name or the name of a place of business or a predecessor in business if you're using it in good faith. So if I am called Coco Chanel today, and mostly I say people in my community would like such heavy names, or I'm called some, which is already a trademark. Then I now decide that I want to come up with a line of perfumes as well, and I want to call it Coco Chanel. Then we must now see as a new entrant, as I come in, do I want to use my name? Would it be in good faith? Would I use Apiyo or Apiyo if I'm Coco Chanel Achieng? Would I be able to use Achieng instead of Coco Chanel so that we do not ride on the, and now the issues of well-knownness will also arise. So then honest practices, honest bona fide description is very, very important when we look at honest concurrent use. Acquiescence. Acquiescence is just a word of saying that you have accepted when someone is using your name or using your name and you're quiet about it. The defense is that for a continuous period of 5 years, someone has been using, and it's the same even for in proper property law. When someone has come into your land and you're quiet about it, then there will be, for us, we call it acquiescence, meaning that you have accepted. This is another case you can look into it, Sony Holdings, that involved the Registrar of Trademarks. Was the applicants appealed and said that their mark is well known, Sony, for electronics. But now the issues that arose is that there is Sony Sugar in Kenya, there is Sony Football Club, forgive me. Our S's and SH's are very difficult. So there's Sony Sugar and Sony Football Club. So it means that these people accepted for a very long time that these marks would continue to coexist with their mark. So now they cannot come in and say that we want to to remove Sony Sugar or Sony Football. There's so many. So then the intricacies of well-known marks also arise, that territoriality also comes in. In different territories, there are certain scenarios that may be different. Maybe when you go to Japan, Sony is well-known, and I still think arguably that Sony is a well-known mark for electronics. But since they allowed, the courts would say that they could not remove these other marks because they had acquiesced. So that's also another danger. So when we look at similarity or confusingly similar, what are we saying? There's signer-safe and signer-safe. So here in this case, I need to go quickly. So these are pharmaceutical products. And then I said we also look at the jurisdiction. There are people who, for them to spell signer and signer would be the same. This mark came before the registrar. One of the registrars allowed it, that both could coexist, because there's an argument usually for pharmaceutical products that the people who are involved are professionals and they are educated. The average consumer can be able to, who would be doctors and people who prescribe, who work in the chemists. But then the High Court overturned because of the slur of the language. Like in Kenya, some people would say signer as signer. And when there would be confusion, pharmaceutical products are very dangerous. Some you would be prescribing the wrong kind of medication because of slur of language. So we look at phonetics. You remember in the morning I said CIFA and CIFA would be adjudged to be not registrable because they're phonetically similar. We look at visual similarity, whether they are identical logos or how the mark looks holistically. And then we look at phonetics, and we also look at the conceptual similarity. What concept does it leave? What meaning does it leave behind the minds of consumers? So then Fair and Lovely and versus Fair and Handsome, this one came before me. For people who know, these are skin lightening creams. Fair and Lovely has been in the market for the longest time, and Fair and Handsome was a new entrant. So Fair and Lovely, these are the dangers, like what I was talking about, Maisha Mabati and Mabati Rolling Mills. Someone using common English languages or descriptive terms as a trademark. Sometimes you become popular and become well-known, and now people start infringing, and you cannot stop them on the basis that these are descriptive terms. Fair means you're getting fairer, and lovely. If you see in the market, we have Dark and Lovely. It's still in that same class 3 of cosmetics. We have Dark and Lovely, we have Nice and Lovely. So there's no way we are going to stop Fair and Lovely. As much as the marks looked similar in my decision for Fair and Lovely and versus Fair and Handsome, maybe I would also want to hear your reactions. The decision was that they would coexist because of the very fact that there were certain other marks in the register. And so the only condition was that now, because this one was produced by Emami, that they would make it Emami Fair and Handsome, so that people can be able to distinguish. So these are some of the challenges of using terms that describe the products within a class. And so you cannot stop the other people. Even when you're grown up and you become popular, people will still ride on your reputation. Phonetic, so we talk about phonetic and conceptual similarity in the packaging. If you looked at Fair and Lovely and Fair and Handsome, there was a lady becoming lighter and lighter, and for the Fair and Handsome, it was a man becoming lighter and lighter. So in that decision, we found that it was conceptually similar. It was more or less visually similar, but now the problem was that there were other marks in the register, so we could not stop them from registering the other mark. There are also certain offenses under the criminal and that are criminal under the Trademarks Act, like falsification of entries. This is now for anyone probably in the office who would falsify anything on the register, maybe saying that a mark is not registered anymore or changing or alterations, then you would be liable to an offense that is punishable by law. There's another one that when you falsely indicate that an unregistered mark is registered, then it's an offense under the law because you're telling people that your mark is registered and yet it is not. And the fees, and you'll pay the forgery of a registered trademark, applying or making anything or a machine or a dice that would for purposes of forging without consent or input, as we earlier said, is also punishable under the law. So these are the things that would amount to someone taking you to court and saying that you should pay them. So other general matters, the use of the symbol registered. I think if you've seen in most of the products, when there's an R or TM, you're trying to state that your mark is registered, we say that it's punishable under the law. We prohibit the use of flags, emblems, coat of arms, the Red Cross. The Red Cross is a humanitarian symbol, so it means something in the world, so you're not allowed to register it. So then again, we also say beware of well-known marks. They are prohibited in all classes of goods and services. Whether there is any connection to those goods or not, you cannot be able to register them. So then other offenses are prohibition of sale or importation of goods, aiding and abetting. If you're aiding anyone to forge or to do any of those acts that would amount to infringement, then you'll be subject to also a criminal offense. A conviction, a court may order forfeiture of goods to the government, depending on what it is. Then there's the restraint of use of the Olympic symbol. I don't know if most of you have seen the 5 interlaced rings. No one is allowed to use that symbol because it means something in the athletic arena. So then the armorial bearings and flags, I've also already said they are prohibited. So that's about it. I was trying to be fast so that it can be a bit interactive. Sarah, there.
Okay. So thank you very much, Elvine, for taking us through that particular section. We have a bit of time to be able to go through some of the questions that have come in. And I think we have a few people who have been able to bring up questions within the chat facility. I'll just invite them to be able to comment or ask their questions as they have indicated in the chat facility. So we have Christine Kipsang has asked a few questions in the chat facility. We have Susan Wendort as well, has asked some questions in the chat facility. And yes, so we can have the two just give their comments or questions that are in the chat facility, and then we'll be able to move on from there. So Christine Kipsang, please proceed.
Hello, please unmute me.
We can hear you, Christine. We can hear you, Christine.
Oh, sorry.
Yes.
Okay, thank you, Elvine. The first question I have is where is the tribunal located? In Nairobi, and does it go around the country, or it's just stationed in Nairobi only? Then the second question is relating to the time you were speaking about infringement of patents or works that have been protected. So I wanted to know whether you can give a positive case where somebody lodged a claim and then they were able to be given positive orders, as in the claim was upheld by the tribunal. Thank you.
Okay. Wendort, you can be able to have your comments as well, and then Elvine will be able to address them together. Wendort, please proceed.
Thank you, Sarah. Thank you, Elvine. I was asking, what was my first question? Whether you educate people on, especially inventors of products, services, do you offer any education, just awareness that they need to patent or put a trademark on their products or services. Then my second question is, if today I just come up with a beauty product where I'm using different products that have been made by other people and come up with a unique product, does it qualify for patenting? Those were my questions. Thank you.
Okay. Thank you, Wendot. Elvine, you can take those two in the beginning, kindly.
Yes, I will. For the Industrial Property Tribunal, it is in Nairobi, unfortunately, only in Nairobi, and it's in South Sea at the Weights and Measures building. If some of you would know where we were, before KIPI moved, we recently moved to our own premises in Lavington, just on Wayaki Way. But before that, we were in South Sea. So that is where the Industrial Property Tribunal is still there, and it's independent. We are not together. And I think that's important to also state that it's now under the judiciary. There are certain things, if you saw an amendment that all the tribunals are under the judiciary, and it's an independent arm, because as you see that when we grant a patent, then the revocation would be done by a different, it's like an appellate. So then it means it's done by an independent body. So the Industrial Property Tribunal, though anchored in the Industrial Property Act, is very independent and different from the Industrial Property Institute. So it's only located in Nairobi. So disputes are handled here in Nairobi, and the composition, if you look at it, it's specified that they have to have the technical expertise ranging from scientists. The chairman has to be someone who can sit as a judge for purposes of, because patents are very technical. So it is the first call before you go to the High Court. The revocation first goes to the tribunal and then now goes to the High Court. I think that's what I would answer. If there have been any positive cases, there are so many. I would have to probably later get you one, or there are many orders. I only picked one for purposes of this to just show you the exclusions, but there are some that we have been ordered to now grant again, or, you know, for one reason or another. So as you know, in the litigation field, there could be an error that was done. I don't have one at the top of my head right now, but yeah, there are orders that would be positive as well. So I hope that's sufficient for Christine, unless she would want to raise anything else. Then for Wendot, education awareness creation is part of our mandate. If you are here in the morning, and it's one of the things like what I'm doing now, we do it constantly. You know, by last year, it's only because of COVID that we are grounded, ideally, that we cannot have gatherings, but we continue using virtual means as this one. But I know we had a campaign, and it was funded by government last year. We did the other whatever, what are they called? The 8 provinces, the old 8 provinces, going around the country. And our target was SMEs, small businesses, trying to explain to them the importance of protection of the intellectual property all around the country. We went around the whole year just preaching, and even to the point that we are helping them to file, or rather to fill in application forms. And, you know, we paid for their stay. We were housed in government facilities, paid there for 3 days for people to leave their businesses to come and listen to us. So as I say, it is a very key area for us. It's a very important area. We continue to do it aggressively so that people can know the services that we render, and the importance of value addition for their products, and and just explaining to them the intricacies and what would help them in one way or another. For beauty products, what you're talking about when you use different products, if you're there in the morning, when you look at the criteria, it's just that simple. When you're using whatsoever, you know, we do not create from the air, or we create from things that are already there. So when we look at the patent criteria, which I talked about in your beauty formulation, if it's a formulation, we will look at what is already there and go through whether it is new now that you have done it in this specific way or mixed it in this manner. Is it new? Does it involve an inventive step? If it's something that is obvious that anyone could have just added maybe glycerin for it to be more, to moisturize it, then probably it will not fit into the inventive step, which is then an obvious rule. And then will it be useful? So those are the three criteria, the main criteria that we use, and against the backdrop of what I've talked about, the exclusions that are there. We look at whether it's a mathematical method, is it a business method? Many people have come to us even for these soaps that are made. There's a certain formula that's out there for people who make, I don't know if you've seen this household detergents. So when you're coming, you must tell us, you must disclose, and we have examiners in KIPI who will look at those compositions and those formulas to see whether it is just a replication of what's already there, or there's something new. At the end of the day, when you talk about intellectual property, we said from the definition that these are creations of the mind, meaning you're trying to tell me that you have done something that warrants an exclusive right to be given to you so that you can recoup back from that which, you go an extra mile. When I'm sitting down to make the beauty product, I take aloe vera, I look at its properties, I break it down and look at the implications that it would have on the skin. And maybe if I mix it together with coconut, what effect would it have? Would it have a skin lightening effect? Would it be harmful? Would it be cancerous? All this is driven by research. When I come up and realize that the combination between, I'm giving an example, aloe vera and coconut oil and maybe avocado would be brilliant in, moisturizing hair or my skin. And I combine it in a way that I'm able to explain and disclose and come up with a beauty product. At the end of it all, it will pass the criteria for patent. The threshold for patent, by the way, is very high. As you can see, we give you 20 years, and you've seen what I have talked about in terms of dispute that arises, that no one can exploit that invention for the 20 years. They have to ask for permission. And I've said in simple terms, permission is giving you money. They have to pay you to use your product. And when you mass produce it, you gain, and it continues to give you the impetus to continue to innovate, such that when I now I'm thinking, okay, can I do something else because I gained from this? It makes researchers continue. But at the end of the day, if it does not reach the threshold of the patent, there's a small patent I talked about, and that's why I was saying it was important for us to go slowly in the morning to explain to you the background of where we come from. There's something we call the utility model, the small patent, when it does not fall into the non-obvious. Maybe you have mixed glycerin and you've added it, and it's not non-obvious, but at the end of the day, you have made it a bit more moisturizing and it's helpful. Then we will give you 10 years. It has to be new. It has to be something that has never been used. If it's that glycerin or that product or that combination, has to be new, and it must be useful in that area of technology or in society. So then again, you can still get that. For the trademark, you see, there are still other avenues, and that's why we tell people in such forums, or rather when you're even advising clients, you don't have to look at a patent only. You can look at other diverse, even for me, when I mix my soap, it might be the same formula, so I will not get a patent. But when I mix it, there's a certain way I do it, it's thicker, it lasts longer, maybe that's different from someone else who dilute it too much. So when I have a name, when someone sees Elvine's detergent, they think Elvine's is a bit better than Caroline's. So I'd pick Elvine rather than Caroline. Probably the same procedure we used, but because of what I have, how I mix it, how I do it myself, maybe know-how, things that I may, just the way I do mine may be a bit different. So then it also gives me a niche in the market. So then I still can register a trademark for 10 years, build on my brand for Elvine, continue and have a niche. So there are many other avenues. The way I make my container, when I look at, we talked about aesthetic value on a product. I make it so beautiful. Some of us, especially ladies, just pick things because they look nice. Sometimes all of them are soap, but because it's contained in a very pretty container, I'll just pick it because I like the way it looks. So then with that add value, I buy it and probably like it, then I continue like that. So at the end of the day, that's what we are saying, that it's not restricted. You're not restricted to one area. That's why I went through them slowly so that you can see where you belong. One of the things that the office has also done in terms of utility models, we have removed the aspect of examination so that we can encourage small innovations, because we realize that for people to get to the threshold of patents is a bit difficult. So what happens is that we do not search. We just do a local search. If it's not in Kenya, that's fine. You get your protection. So it helps people continue, you know, this energy saving GCOs, you know, coming up with ideas of utilizing what is there in a better manner. Yeah, I think.
Okay, thank you very much for that. We had Florence raising her hand, so I'll give an opportunity to Florence to be able to give her question or comment. Florence? Florence, are you there?
Yes, hello.
Okay, yes, Florence, you can go, please.
Yes, I just wondered, you know, Ivan, to comment on the issue of the tree top. There was a brand many years back. Those who are old enough to remember, there was tree top drink. And it disappeared from market for a long time. And recently I saw like it has come up, but I wondered whether it is the same company or somebody bought the patent rights or what it is. Yeah. Hello?
Okay, yes, okay. Thank you for that, Florence. So Elvine, you could take that, and also as you take that, you could give an indication of some of the costs that are involved in the disputes that are, you know, within the sector as you take Florence's question as well. Thank you, Elvine.
Okay. Florence, tree top is painful for me because I might not be very old, but I remember that tree top and the advertisement that used to be there when someone is plucking oranges up that tree. And that's now the beauty of branding, that it had reached a place where we had, you know, there's loyalty, there's brand loyalty, and so it disappeared. So it's just the intricacies of intellectual property. When I talk about 10 years, you can renew it. By the way, trademarks are renewed indefinitely. For patents, it's only up to 20 years. It goes back to the public domain, and so people can be able to exploit it. But for a trademark, you can be able to hold it. Like KIPI has been there. I think it's the oldest in our register from 12 or so till today. Some of the old marks, thermos has been there for a long time. You know, now we don't even know whether vacuum flasks, we call them old thermos. But then treetop fell into I think it fell out. They did not renew their mark. It disappeared from the market. And I think they sold and they sold the rights to someone else. He's using, it's just funny, it just annoys me. But there's nothing much we can do. It's someone's property. Once they sell it and they use the same mark, that's what happened to Blue Band. Bidco sold out. It was sold out to Bidco. So this is part of intellectual property, that it's property, it can be sold, it can be licensed, and that's just the reality. And people are making billions out of it and millions out of it. You can imagine if someone was to sell the Apple trademark today, how much it would be. So it's just, and those are the dangers when we talk about a well-known mark, when we're saying that when it's protected, it's protected whether registered or not. It's only that the registrar can do so much. We cannot go to the market and force this person to stop using the treetop mark if he has bought it from the owner. So you see, once he's bought it and now he's making diluted juice, you know, it's not the juice that we knew. It's probably going to die a natural death eventually in the market, but then those are the intricacies of property. You can't stop someone to sell their property or not. But one of the things I'd also highlight is that when you're coming for application, like for instance, if Treetop had gone out of the market and they had not sold the mark, and you come and say that you want the Treetop mark because it's available, as I said, we will not allow it. As the registrar, we will not register that mark, because then it will cause confusion in the market, because we knew, because of the notoriety that it had built and the reputation that it had built, we will not allow any other person. The law allows us to refuse on that basis. But then again, if it is sold, there's nothing we can do. We will register we call it an assignment. We will register the assignment, and forthwith, the mark is registered in the name of the new party who has either bought it or licensed it. And this is between parties. It's not something that we can do. So that's the unfortunate part about the Treetop mark.
Thank you. Thank you so. Hello.
Hello.
Yes, thank you so much for that response. And I'm just wondering whether it is the same thing that has happened to Kerrigate Water, because if you check it closely now, it is owned by Coca-Cola.
Ah, Kerrigate. I'm not sure about that transaction. I'd have to check.
Okay, but
I'll have to check. But that's what happens. Some people sell off their rights. You know, if you're given a good deal and the mark was a good mark, it will continue in that way. Like now, if you see, I think Blueband has been bought by a US company, I hear, sold at a very high amount. And now they're coming up with mayonnaise, peanut butter. I don't know if you've seen that in the market. So depending on the person who buys this, they'll try and brand it again in another way. That is beyond us. That is
so
beyond
my question then is, who protects the citizens from being fooled that the same product they used to know is the same? Because like now, for example, if Kerrigate has gone, to Coca-Cola, who have been producing this other brand of water, and now, we knew Kerrigate as a very good product. How assured are we it's going to be the same? And we go buying the same product because of the name, that we knew. How are we protected as citizens?
I think the only way we can protect you in terms of government is just for those transactions to ensure that they are properly done. But we must also have it in the back of our minds that these are individual rights. Just the way you own land, once you have been given the title deed, once I give you the certificate of, it's only that now this is intangible property. That's why it becomes a bit different, and we are thinking, what is the government doing? Many people come and tell us, KIPI, you're keeping quiet, our trademarks are going, our marks are going. The issue is these are individual rights. And just as we say, when you have a right over your own property, if it's my house, I can sell it to whomever I please. Even as a neighbor, if I think that the person next to me is a thug, you should not be the one to be sold for that house. There's nothing we can do, because they have made an agreement, they have agreed on the sale. All that comes to the office is the agreements showing that this has moved from this person to this person, and we have no say. And this is world over. You have no say in terms of who gets what. So the only safeguard is that at the end of it all, those proper authorizations must be made and recorded in the register. Whatever the process I went through, we will vet, as I've said, whatever is against public morality, the government will come in. There are certain stringent issues that would arise that we will not allow in terms of how far we can go. But then again, it's private property. So it's just for you to now realize that Kerrigate is not as nice as it used to be. You're free to choose Dasani, you're free to choose Orange. I don't know which other water brand we have. You're free to choose whichever. you know, or continue to remain with Keringet if you still feel that the quality has been maintained. Yeah, so I guess that's what happens. So then for the costs for dispute, the disputes that we have, as I said, it's I don't know if you want the total cost or the in the processes that I talked about, it could get to what I can like roughly say is that instruction fee. I don't know if you want instruction fee for advocates or the fee that's payable to the office in terms of when you're coming. Please clarify so that I don't give you figures and you faint.
It's okay to give the just general indications of the different areas. So if it's the different fees and the fees for the advocate, just go on. That's fine.
Okay, going by what comes to the office, it's just the preliminary, what I talked about, like for trademarks, when you're coming to bring in the notice of opposition, it would be around 6,000. And then the counter statement is also paid for. So is it 4,000? One is 416, so that's around 10,000. It's not much. Then the statutory declarations are free. Your evidence is free. Hearing fee is 4,000 shillings for each party for you to be heard. Extension fee is 1,000 for 30 days, 2,000 for 60 days, 3,000 for 90 days in all those in the processes I had shown. So then if you're a foreign company or if you're a foreigner, then yours will be calculated in dollars. The fee schedule, as I said, I wouldn't have all the fees in my head, but all the fees are on our website, on the fee schedule, trademark fee schedule, patent fees. It's not much. For a local, it's not much. Litigation is not much. It's not very expensive, but it could be expensive because it takes time. Sometimes it takes a long time. We also tax. When we get to taxation, when you lose, because we go through, when you lose, you'll pay. So once you do that, then the advocate's cost could run up to 120 for instruction fees. Some have gone to millions depending on the complexity of the matter and what mark, the value of the mark that is involved. So then it can range from 120, 200, 300, 600 millions, depending on how long it has taken. And as I've said, we give a lot of extensions of time because we are getting evidence sometimes from abroad. And by the time the lawyers talk to the people, and no one, by the way, foreigners cannot act on their own behalf. You have to have an agent in Kenya for purposes of our transmission of documents. We do not want to be sending documents to the US, to the UK. So for anyone who is a foreign company or a foreign applicant, you must apply through a local agent who is registered. Now, under the Industrial Property Act, you have to be a patent agent registered by the Institute. But under the Trademarks Act, when it gets to disputes, it's important to have a lawyer who can be able to draft for you, because then they are conversant with the laws. So we don't deal directly with foreigners. So it means the costs are a bit higher in terms of transmitting documents. It takes long. We have matters, they take so long. So it's a good opportunity, and we are going to talk about it in the next session for mediation, and I'll try to show you the areas where you can come in terms of now bridging this gap, and by just simple knowledge and awareness that people do not have, that they want to go and fight it all out, and yet there are other avenues that they can resolve matters, so to speak. I don't know if that gives you an overview.
Yes.
We also have security for costs. I think it's one of the things that passed my attention when I was talking about dispute resolution, that when you're a foreigner, because we deal a lot with foreigners, defendants, when the defendants are foreigners or plaintiffs, people will come up with a claim for security for costs in terms of if this person loses, they don't have any establishment in Kenya, nor do they have any commercial establishment where they can go and attach. So then they put in a deposit of certain amounts within the country. And so that is also another area where we also get a lot of litigation in terms of the disputes that arise before us. Yeah.
Okay, just probably the final thing on the cost, it is standard regardless of whether it's an individual or a company, or it's the same fee all across. Eh?
Yes, yes, there's
Okay.
no, yeah, only for inventions, by the way. For inventions under the Industrial Property Act, we give waivers, especially like now, if someone was to come up with an invention for, I said it's a bad example or a good example, whichever, for Corona, we would give waivers. So there's a waiver because you can come up with a good invention, but you're not able to afford the fees. So it's an application that is brought before us, and we are able to assess and waive fee for the person, especially youth, now coming up with ventilators, things like that, things that, you know, PPEs, masks, if you're coming up with something, and especially, and it has to pass through the criteria we talked about, new, you know, once it passes the criteria, we take it through the board and they're able to waive fees. So at least we can waive fee for inventions, again, for the whole purpose of advancing technology, so that we don't stifle technology. If someone has a good invention and they're not able to afford our fees, we can waive. But for trademarks, as you see, these are trademarks. They are used in trade. So 10 years, I think, for 12,000 shillings, we talked about yesterday, which is or rather in the morning, it looks like it was yesterday. 12, we started so early. So 12,000 would be, you know, commensurate to 10,000, to 10 years. We give you 10 years. It's like 1,000 every year, you know. And renewal is 4,000. So it's not much. And you again renew it for 10 years and you can renew it indefinitely. So there are also other charges for change of name. If you change your name, if you do other things. So it depends commonly, because we say you are in trade. You know, you are not an idler per se. You're going to use these marks in trade. Yeah, I hope I was able to answer.
Yes, very much.
Questions.
Appreciated. I'll just give an opportunity to Dr. Mshelule to be able to make some comments, and then Wangari will also be able to make some comments before we are able to conclude this session in the next few minutes.
Yeah, can you hear me?
Yes, we can.
Okay, to me, I think it has been an eye-opener in what's happening in KIPI. One, I didn't know that they do mediations there. And it has been a really wonderful presentation, just letting us on what goes through in the intellectual property area. Because I know in the pharma industry, there are many issues, especially around the names, like Xenasafe and Xenasafe, the way she was saying it, it's a big issue within the pharma industry. Those are my comments.
Okay, thank you very much for that. Wangari?
Okay. Ladies and gentlemen, good afternoon today, and I would really like to thank our session facilitator today, Elvine Apiyo from KIPI, for journeying us through from 7 a.m. and up to now. We are in our second session. And just for your information, this discussion started last year with KIPI when the Wasilianahub team had the opportunity to interact with the KIPI team, WIPO, World Intellectual Property Organization Forum, and that is where this discussion started off. And once we got into the COVID season, so it was very clear that we would not be able to have a physical session, and that is what has led us to a virtual event together. And I'd like to thank you, Elvine Apiyo, for keeping consistent in enabling this to really happen. Please pass our regards also to your team and officially to the registrar. So as we had requested in the morning, we have received their names. A number of participants have sent in their names, and those are the names that will be used for their respective certificates. This session that was running until 3 p.m. enables us to be able to be back for our 3:30 p.m. to 5 p.m. session. And the 5 p.m. session is aimed at positioning mediators to serve in industrial property related dispute resolution. And it's also our closing session where we'll also be able to acknowledge ourselves as the dispute resolution practitioners who have an understanding of the various forms of intellectual property, industrial property and industrial property rights. We've been able to understand the nature and the causes of disputes. We've been able to gain an understanding of how to mediate related disputes with greater understanding. And also we can be able to present ourselves competent to grow specialization in this area. For the Wasilianahub Associates, this is a 3-level course that we are undertaking. So level 1, which we are running with KIPI, is on industrial property, and it also includes a program or a course with the World Intellectual Property Organization Academy. You have received it on your email. And it's a distance learning course, which you will be able to sign up and you also undertake it. Level 2, we will focus on copyrights and also in related areas. If you remember early in the morning, Elvine, our KIPI facilitator, clarified that they handle industrial property. And we have another agency, which is Kikobo in Kenya, which handles the other parts which relate to copyright and also other related areas. Together with that, for our mediator associates, we are also directing that you undertake also the World Intellectual Property Organization Academy course that is on dispute resolution. It focuses on arbitration and mediation. And so that is at level 2. And then at level 3, we will be having the practical mediation assessment so that then you're able to say that you're all around and also have been assessed in this area and can be able to add it to your commercial mediation portfolio. We do hope that for all who joined in at level 1, that you're able to add this to your commercial mediation portfolio, and especially after we have listened into Elvine for the next part of this particular discussion, where she will be telling us how do we plug in. Elvine, I assure you that that is a part that we are listening even more. We were very awake in the morning and also at this particular time. But also just to emphasize that we want to be part of the solution. And one of the things that was exciting when we first interacted with you is that you say that there is a place for the alternative dispute resolution mechanisms, and that's what we are looking forward to. So back to you, Sarah, and also Sarah, thank you. And we are looking forward to go and have a quick cup of water, and we will be back at 3:30. So Sarah, back over to you.
Okay, so thank you very much, participants. We will be having a little break. The next session begins at 3:30, where we will be looking at how do we engage as mediators. Just to close this particular session, we will be having the national anthem again as our prayer as we bring this session to a close. So the national anthem in English: O God of all creation, bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace and liberty. Plenty be found within our borders. So thank you very much for joining us for this particular session. We shall close this session, and then you will be able to log in again at 3:30 for the final session of this masterclass with Elvine today, the 16th of July, 2020. Thank you.